finally ready to start. Again, apologies for the extra bit of time it took to get our tech up and running here. But I think we're ready to go now. Thank you all for coming to our inaugural session of the Faculty of Law Research Series for this year. I'm very excited. We have an excellent group of presenters throughout the term and into next year, starting in January. But for the first one, I'm very excited to welcome one of our new professors here, Professor Maharaj, Maharaj, and he joins us from the University of Manitoba. And his talk today will be on equitable characteristics of mitigation, which is extremely exciting to hear what he has to say. And would you please just join me in welcoming him to give his presentation?
Well, thank you very much, everybody, for coming today to my presentation, and thank you very much to Blair for that kind introduction and welcome. So, as you can tell from the title slide on the screen, today's topic is mitigation. And before I get into the nitty-gritty of what I think about the equitable characteristics of mitigation, I'll probably have to say a few words about what mitigation actually is, because some of you will not have thought about it in a little while, for which you can be excused. So, great question. Unfortunately, as I found out when I decided to work on this topic for my doctoral dissertation at the University of British Columbia, mitigation as a doctrine doesn't lend itself to a very easy or pithy explanation or description. Unlike remoteness, for instance, which is sometimes compared or contrasted with, mitigation kind of needs really not only its own chapter, but really almost its own book, which is why I wrote my doctorate on it, because my dissertation is basically book length. What it does, in short, though, is regulate the recovery of damages in civil actions like contract and tort, and also potentially actions under statute. Now, the best way for me to explain how it does this is probably by way of examples, because those are typically more illustrative than what I can say in the abstract. So we'll start off with what is the foundational case in mitigation, Staniforth and Lyle from 1830, also a case that I appreciate because it involves my home jurisdiction, New Zealand. So what happened in Staniforth and Lyle? Well, the owner of a ship, Staniforth, contracted with the defendants to sail to New Zealand from the UK. That is a journey of some months if you're doing it even on a regular ship, but this is a sailing ship. So this is a long way to go. Now, once there, the vessel was supposed to either load a cargo, which it would transport back to England at a set rate of freight, or they'd get 500 pounds just for their trouble for sailing all the way to New Zealand. Not bad considering how far it is and the hazards of the era of sail. We're talking scurvy, pirates, storms, you name it. Now, once the ship got there, though, unfortunately, there was no cargo. They couldn't find any agent of the company that had contracted with them to go down there, and they couldn't find anything to load. So they just kind of sat in harbor and wondered what to do. As it turns out, they went back to England because there's not really much for them to do down in the South Pacific, but they took the long route. They went via what was described in the decision as Batavia. And I've tried to figure out where exactly Batavia is, and I can't really locate it. I'm just going to assume that they went via, I think, the Dutch East Indies and collected spices and traded along the way. And as it turns out, made a pretty handsome profit. When they got back to England, though, after the circuitous voyage back to Old Blighty, they decided they were going to sue for that 500 pounds they were supposed to get in lieu of a cargo. And the action goes to arbitration, then from arbitration it goes on appeal, then it goes on appeal again. And finally, they get a decision in, I think, what would be the modern forerunner of the Court of Appeal. And what the court concluded is that despite the fact the plaintiffs had sailed all the way to New Zealand, as promised, had not gotten a cargo, and had not gotten the 500 pounds that they were promised, they could not collect 500 pounds in damages for this breach of contract. And the reason being, according to the court, that you had to balance loss and gain as circumstances had played out against the claim. So the claim here was for 500 pounds, which is what the plaintiffs were expecting to get, and which is what they were entitled to get under the contract. But the court asked, have they really lost 500 pounds? Is that loss really where they sit today after their voyage? And in truth, because of the very successful trading operation they undertook on the way back to England, they didn't actually end up losing out on 500 pounds. In fact, they made more money going the long way back and trading for spices and whatnot than they would have made if they had collected the cargo that they otherwise expected or had gotten the 500 pounds. So in the end, they were actually better off, according to the court, because of the defendant's breach. And if you're better off, Why grant you damages? Damages are supposed to put you in as good a position as you ought to have been if the contract had been performed. And guess what? You're in a better position. So damages for who? No damages awarded. Now, fast forward about 140 years, you might think, all right, so contract cases, you're suing for profits or some sort of amount that you would have made as a consequence of your contract, and you turn out to have made better money somewhere else. Okay, I can kind of see why a court might decide that you don't need to be paid contract damages for the breach. But mitigation doesn't just apply to contract. Mitigation also applies in tort. And what's more, courts have said for quite some time that the rule in contract and in tort is the same. This is the same doctrine operating in different contexts. So operating in the context of contractual claims, tortious claims, sometimes also claims of compensation under statute, like workmen's compensation acts. And this case was a tort case. And likewise, recovery for the plaintiff turned on mitigation. So the plaintiff, Bellingham, was a driving instructor. And he was unfortunately, I think somewhat ironically, rear-ended while sitting in his parked car. Clearly, the defendant ought to have taken his services up instead of doing what she had done and driving into him, but that was not what happened. So the plaintiff was unfortunately badly injured as a consequence of this accident and had to take time away from his growing business teaching people like the defendant how to drive. That, of course, led to business losses. He didn't make the profit he was expecting to make, and he also missed out on the opportunity to purchase a newfangled piece of technology, which was new to England at the time, a driving simulator. Imagine one of those things that you played in at an arcade as a kid, for those of us who are, I don't know, millennials. Like you sit in, you get a little steering wheel, tend to drive, great fun. This was used as a driving instructional aid, and apparently it was a very hot commodity at the time in the driving instructing business. Now, Bellingham didn't get to buy it because his business basically had to pause while he recovered from his injury. What subsequently happened, though, was that the competitor of Bellingham, who bought the simulator, was not as good a business person or driving instructor as Bellingham was. And the competitor went out of business and their assets were sold in liquidation. And as it turns out, by this time, Bellingham was back on the job, he'd recovered from his injuries, and he was able to buy the simulator at a very, very steep discount because of the liquidation sale. So in the end, whilst Bellingham had lost out on certain aspects of the business that he could have been running while he was injured, he did benefit from having waited to acquire the simulator because he got it for almost a tenth of the price. And this was a very expensive piece of equipment at the time. Remember, computer equipment still relatively novel. The idea that you can do something in a virtual environment with a screen, pretty brand new. And when Bellingham decided to sue for damages, as you would as a tort victim, he had to contend with the fact that the defendant's counsel argued that because he had managed to save all this money from having purchased the simulator in liquidation instead of buying it full price, that had to be taken into account in reducing his damages, because he was claiming damages not just for his injuries, but also the business losses he had experienced because of his business being disrupted by his injury. And the court concluded, yes, you do have to take it into account, Mr. Bellingham. You may have been harmed, but you did save some money in the long run because you got to buy this expensive piece of kit for a lot less. And that means you partially mitigated the loss that you suffered because you wound up actually making your situation a bit better than it would have been otherwise. And thus, damage is reduced. So mitigation here applies to really any claim for something in the nature of compensation. Either it's for contract where you are claiming compensation for what you were supposed to get and didn't, or in tort for damages to return you back to the situation you would have been in before the tort. In either instance, if you have done something that actually reduces the scope of what the other party would have to pay you to get you to where you should be, your damages will be reduced. And you might think, well, that seems awfully friendly to the defendant. It seems very lenient, relaxed even. But that much appears to be settled in Anglo-Canadian law. This is what will happen if you have somehow managed to improve your situation, all on your own, regardless of what the defendant did to you. And now, if that was all it was, you might think, okay, I suppose one can live with this. It seems odd, but so be it. But wait, there's more. So in circumstances where you have improved your situation because you took steps that did in fact reduce your loss or make a gain for you somehow, some way, despite what the defendant did, you could say, all right, fine, you're claiming damages that you didn't need to. because you actually didn't end up suffering as much of a loss as you claim. In some circumstances, though, imagine that instead of having taken the step that would have reduced your loss, you didn't, but you still sued to recover damages for the loss that you say that you have suffered. The other side, the defendant, may have something to say about that. Now, in Southcott's case, Southcott was a special purpose company that was incorporated solely to buy a piece of property. I believe it was a school from the Toronto Catholic District School Board, which I've abbreviated here because it's a bit of a mouthful. So the parties enter a contract, sale and purchase of the school so that Southcott can turn it into condos, presumably. I mean, what else would you do? Now, unfortunately, for Southcott, the school board later reneged, tried to pull out, perhaps because they decided, well, maybe we should keep the school open, or maybe they found that there was a better development opportunity elsewhere. I'm not entirely sure what their issue was, but they tried to weasel out of the deal. And as I have told some of my students, contract law abhors people trying to weasel out of things. And on that basis, you would think that the plaintiff, Southcott, ought to have been able to recover some damages for the lost business opportunity for developing the land. And yet, the Ontario Court of Appeal and the Supreme Court held that Southcott could have brought another property instead, and as such, could have avoided the lost opportunity to develop land and make a profit, and accordingly reduced Southcott's damages to basically nil. So here, Southcott's claim against the school board was basically rendered nugatory because of mitigation, because mitigation said that even though you didn't do something here that would have saved you the money or helped make the gain you expected, you should have done it. And because you didn't, guess what? No damages for you. Again, this seems awfully defendant friendly. And personally, I hate this case and think it was very badly decided. I think the dissent from McLaughlin CJ, she was then, is by far the better decision. I think the majority is way off track. But as with all things SEC, it is the law, whether I like it or not. And this does reflect to some extent what mitigation is and what it does. So it reduces damages at times when you have saved a loss that you might have suffered otherwise, or made a gain that reduces the loss of benefit that you would have expected to get under a contract. And sometimes it reduces your damages just because the defendant says, well, you could have tried harder. And that seems a little rough, but there's a rationale behind all this, which I will explain. So the gist of what mitigation is can be summed up pithily by, well, reference to the famous statement of Viscount Haldane in British Westinghouse, which is as follows. I'm not going to read that out verbatim because I'm sure some of you will have read it and you probably guess. Basically, if you take steps that are reasonable to reduce the loss that you would otherwise suffer, and you manage to do so, then your damages award should be reduced accordingly. And if you don't do it when you should have, guess what? Your damages will also be reduced accordingly. So if you are a plaintiff, you must tread a very fine line in order to recover anything according to the doctrine of mitigation, because we're all supposed to do whatever we can to try to save other people from liability that they otherwise are responsible for. Now, where does the equitable component of all this come in? Well, I'm not the first person to suggest that mitigation has some equitable aspect or character to it. In fact, there are at least 3 other folks that have said it prior to me, one of whom is Justice Laforet in a case called Canson Enterprises and Boughton. And in Justice Laforet's words, he said, I have no doubt that policies underlying concepts like remoteness and mitigation might have developed from an equitable perspective. I'm not sure what it means to say that you have no doubts and then to say might, but that is his statement. And I don't know that I agree at all about the idea that remoteness has any equitable character either. Mitigation, though, I think he was on to something. And others like Sutherland, a famous US author and contracts from the turn of the 20th century, likewise thought that there was an equitable route to the doctrine of mitigation because it seems to reflect an impulse deeply embedded in the judicial psyche to save people from unfortunate consequences when they can. And this manifests itself in the context of mitigation in the following ways. So, first, it doesn't seem to sit neatly in any common law body of doctrine itself. So I don't think you can describe it really as a tort doctrine or a contract doctrine. And courts themselves say that it's a unified doctrine. And it's even applied outside of what we would think is black letter private law to statutes, which on its face seems a little odd unless this is somehow coming from outside what we would strictly consider the legal system to regulate or ameliorate the harshness of the common law or statute, which is, funnily enough, what equity does. It's also just not really amenable to being distilled as a single rule. If you've ever looked at McGregor on damages, their chapter on mitigation has a series of rules. I can't remember how many exactly, but it's quite a lot, because you cannot actually sum up in one rule what exactly mitigation does. So it is amorphous. It applies across the board, and it seems to be more of a principle rather than anything hard and fast that which we might otherwise be able to describe as a doctrine or rule in the conventional sense when we think of the common law, like remoteness, which you can sum up in a sentence, depending on which body of private law you're talking about, whether it's contract or tort. So that would mean, if I am right, that there is an equitable approach to applying this doctrine to the problems arising in contract or tort when somebody is trying to sue for damages to decide whether or not a person either has their damages claim reduced or whether that damages claim ought to be allowed. And the good news is that an equitable approach to mitigation doesn't always adversely affect the plaintiff. In some instances, an equitable approach to mitigation actually favors the plaintiff by allowing them to recover in circumstances where you might otherwise, on the old-fashioned view, decline to let them recover damages. So it mitigates the rigor of law in that way by allowing them to claim compensation for the wrong done to them, despite the fact that the strict rules applicable might otherwise say no. And in so doing, I think what mitigation is doing is trying to further the purposes embedded in the rules of recovery applicable to contract, tort, or perhaps under a statute. Now, as always, I like to give examples of these things because I don't think it's otherwise particularly clear what I mean. So 3 areas in particular are going to be examined in this presentation. The first is whether to grant relief from liability. So that's basically the situations we were looking at before, where the court decides, yes, plaintiff, you have a cause of action. Yes, it is valid, but no damages for you. The second is whether to permit recovery for costs of mitigation, because mitigation, as a series of steps that you may have to take after a wrong has been done to you, may cost you time and money, or may actually make your situation worse because maybe your mitigation is going to actually deepen the problem, as sometimes happens. And the last is whether to hold the gain to the defendant's account. You recall from Staniforth and Lyle, the plaintiff in that case ended up making money. The question was that gain really something that the defendant should be able to point to as eliminating the loss in question so that they didn't have to pay damages? Was that right? Well, mitigation has opinions about that have changed over time. And I think the more recent cases on this really demonstrate a shift in the court's thinking that makes this look a lot more equitable in nature than the old-fashioned approach evidenced in Staniforth itself. So whether to grant relief from liability, the first one. Now, occasionally, authors, judges try to describe mitigation or explain it as an aspect of causation. They say that basically, because the plaintiff here either could have acted and didn't, or did act and managed to somehow prevent an aspect of the loss otherwise flowing from the breach or wrong occurring, there's no actual connection anymore between the defendant's wrong and the loss suffered. So if I could have taken a step and I don't, guess what? That's on me now, not the defendant who may have otherwise set the stage for the eventual loss that did occur. What I think, though, is that whether or not the plaintiff could have prevented the loss is not actually determinative in many cases. Instead, what the particular plaintiff could have done in light of their particular circumstances will usually have the biggest impact. Now, what do I mean by the particular circumstances of the plaintiff? Well, 2 Canadian examples, I think, help dispel this out. One is a case called Costello and Cormier Construction. It's a New Brunswick case about a couple by the name of Costello who buy a little house that turns out to have a problem with the basement. It floods. The seller of the house was a construction company that was renovating homes and flipping them and so on. And when the when the Costellos discovered that this house had a leaky basement, it took them a while to figure out what to do about it, even though their things, including their washer and dryer, were partially submerged in water for many months of the year. They investigated ways to fix the cracks and the leaks. They investigated whether or not they had a viable claim against the builder. They investigated whether or not it was possible to do remedial work outside the structure to prevent the leaking. It took them a while. It took a few years. And in all that time, the leaking got worse. And the court in that case was asked, well, do you really think that all this additional loss that's occurred in the years since they first discovered the leaky basement ought to be the builder's fault? And the court said yes. Because whilst the Costellos certainly could have taken steps earlier than they did, in the court's opinion, a couple like the Costellos needed time to figure out what was the most effective and viable strategy for them. They didn't have the money to fix the property, and they also didn't know whether or not a lawsuit against the builder would succeed. So they needed time to both investigate the practical options for repair and their legal options for recovery before they knew what they could do. And so for them, more time was allowed. Strictly speaking, you might say that, well, as a matter of causation, that shouldn't be the builder's fault, because at the time that the Costellos knew that their basement was partially a swimming pool for most of the year, they could have done something about it. This is no longer just on the builder. But the court was not of that view. And I don't think that causation thus adequately describes what happened in this case. And if you contrast it with another decision, which is quite similar, Marigold Construction and Norem from Alberta, another leaky building case, but one involving a large building, an apartment block constructed in Calgary, being built for a large property investor who had more resources, had access to better legal advice, and nonetheless also took a few years to fix this leaking. The court's conclusion in that case was, well, you might have needed a bit of time to figure out what to do, but for a company in the business of building residential developments and housing and apartment blocks, this shouldn't have been particularly complicated. You find a way to stop the leaking, even if it's going to cost you money, because the structure is partially made of wood. And if you don't, the long-term damage is going to be a lot more expensive to fix, possibly to the point where you can't use the building at all. So in that instance, the court's patience was much, much more curtailed, not just because, as a matter of causation, the plaintiffs had the ability to do something much quicker than they did, but simply because you could expect more of a sophisticated commercial party. And so the character of the individual claimant had a significant effect on the court's assessment of whether or not a party not only could have mitigated, but whether they ought to have mitigated. And thus, I don't think causation can be an adequate explanation in and of itself, because the court is not assessing what is literally possible or what has literally or mechanically caused the loss, but whether or not the particular individual ought to be seen as in some way morally blameworthy for not having stopped it. But that's not all. So, a defendant has the ability in any circumstance to plead mitigation. And funnily enough, if the defendant doesn't plead a failure to mitigate, it doesn't actually apply. The court can only consider a failure to mitigate if the defendant raises it in argument, allowing the plaintiff to respond. A plaintiff does not have to argue that they have mitigated or that any effort of mitigation shouldn't be counted to reduce their damages because the profit is not related to the events of the breach or the other wrong. It's always on the defendant to make their case about this. But a defendant who is trying to make their case about this, even if they have a particularly clear-cut argument as to what the plaintiff ought to have done instead of what they did, isn't necessarily going to be listened to, because unlike a conventional, I would say, common law doctrine regulating the recovery of damages, the court doesn't just consider the plaintiff's behavior. The court, considering mitigation, considers also whether or not they have a party before them who has the right to make that case. They ask whether or not it lies in the defendant's mouth to make this argument, because the defendant really, fundamentally, is making a prayer to be relieved from the consequences of their actions. So if a defendant in some way abets or encourages a plaintiff to pursue a course of action that is inevitably going to make the matter worse, they cannot complain that the plaintiff has failed to mitigate. And a famous example that some of you might remember is Esso Petroleum and Martin. What happened in the Esso case? Well, Mr. Martin was a particularly deft businessman who was sought after by Esso Petroleum to run one of their petrol stations. This is back in the 50s. Gas stations are all the rage. Post-war, everybody's got a car. This is all on the up and up. Unfortunately, Esso Petroleum makes a huge blunder assessing the likely throughput of gasoline at the particular site they encourage Mr. Martin to take. That blunder means that Mr. Martin never turns a profit. And within a few years, he is financially on the ropes. It's clear to everyone that a mistake was made in the initial assessment, but ESSO nonetheless urges Mr. Martin to stay, saying that they'll offer him credit and better financial terms and so on to try to make the site viable. Nonetheless, nothing improves. Mr. Martin basically goes completely bankrupt. And not only that, ESSO sues him. They sue him to retake the site and for immense profits and so on from occupation and use of the land, which seems awfully cheeky of them, but large oil companies are not exactly known for their virtue. Now, Mr. Martin counterclaims for the losses he suffered as a consequence of the mistake that ESSO Petroleum made. The claim could be understood either for negligent misrepresentation or for breach of warranty, because the throughput of the site may have been warranted by ESSO, but either way, mitigation's application is the same. And basically, what the court says, and particularly stridently Lord Denning, is that you can't blow hot and cold. You can't have your cake and eat it too. While Mr. Martin's initial losses were in no way or shape his fault, because he could not have known that the estimate given to him was inaccurate. Now, whilst he made a decision to double down on the site and continue to operate the business, he nonetheless cannot be held responsible for that, because he only did it and only managed to continue operating for as long as he did, deepening his losses, because ESSO Petroleum wanted him to. ESSO Petroleum actively encouraged him to continue in a course of action that was going to make him financially worse off, and they have to own that decision. And so, even though you could say that at the time of the renewed lease and the new financial terms, Mr. Martin clearly made a decision that was informed, you can't say that he is to blame, because ESSO Petroleum basically left him with no choice. The initial mistake had been too catastrophic for his financial fortunes, and as such, it made ESSO Petroleum as a defendant, well, defendant by counterclaim, because remember, they sued Mr. Martin first. It made ESSO Petroleum seem particularly unworthy of the court's assistance wearing its equitable hat. Because if you're asking for the court to let you off the hook for something you're otherwise obliged to pay for, why should it, if you're the one here that's responsible for the entire mess? There is also another decision, which comes from Lord Roskill, back when he was just Justice Roskill, in 1967, called Panax and Harlow and Jones. In this case, instead of post-breach realizations that something was amiss and one of the parties, the defendant, encouraging the plaintiff to continue in a course of conduct that was not good for them, we had in Panax a situation where a defendant who was a purchaser of steel under a contract for, I guess it was an FOB contract for the sale of steel internationally, tried their best to get out of the contract when the market for steel took a massive nosedive. Now, they tried to get out of the contract by basically forcing an error on the plaintiff's part, by asking for changes and then claiming that, oh no, we didn't agree to vary the contract, you must deliver as initially promised. Now, this led to a situation where the plaintiff just couldn't perform the contract as they had initially intended, and thus a forced error was effectively obtained, meaning that on the face of it, the defendant could walk away from this contract, which was now not in its financial interest, and could leave the plaintiff with a whole bunch of Soviet steel that they couldn't sell at any price that was favorable. In this instance, what happened after the parties purportedly ended the contract was that the defendant made an offer to buy the steel at a much lower price. Now, post-breach offers to repurchase goods that are now worth less are not, well, not worth less, but worth less, are not uncommon. But was the plaintiff in Panax expected to take that offer? Was failing to accept that offer an act contrary to their obligations under mitigation? Well, the court said no, or Lord Roskill said no. Why? He doesn't spell it out so clearly, but I think he just thinks that the defendants in that case were so dishonest that they could not possibly plead mitigation as a basis for reducing their liability, because they were the ones who were responsible for this whole catastrophe in the first place. So causation by itself doesn't seem like an adequate explanation for these decisions. And it doesn't seem like an adequate explanation for the way courts and judges have considered the problem, because it seems as though they're asking themselves, more often than not, is the person before me who is making this claim or is asking for my assistance to reduce their liability, who is asking for relief from the ordinary incidents of this cause of action brought against them, worthy? And in Pan X, it looks like the defendant had unclean hands, and that the court has literally decided to deny a prayer for relief because the person making it is not worthy of the court's assistance. And that seems quite markedly different from the way mitigation is ordinarily described. Because remember, if it's only about causation, and if it is about a plaintiff's duty to take certain steps, it shouldn't matter what the defendant has done. And yet, in case after case, court after court has decided that an unscrupulous defendant doesn't get to have its cake and eat it too by claiming a failure to mitigate after they have breached a contract or committed a tortious wrong. Now, the second scenario is recovery of costs. Now, this example is going to be a little more interesting, so I can assure you, you will have a moment of respite from the more dry details of gas station throughput. Now, some authors, and some very esteemed authors, also describe mitigation sometimes as an aspect of remoteness. And when I think of the leading luminaries who take that position, one is Stephen A. Smith. So Stephen Smith of McGill, who has written a very influential book on contract theory, one that I've read. He takes the position that mitigation is just remoteness. And if you wonder what that means, well, it means that if a party would have been expected to take certain steps after the wrong has occurred, and they don't, any loss that continues as a result or because of the failure to take that step must now be too remote for the plaintiff to recover, because one expects that everyone you're dealing with in the world is reasonable and they will do reasonable things. They will not exacerbate their losses. They will do what they can to stem or cut their losses. So if you are an unreasonable person, your behavior is clearly outside of whatever rule of remoteness applies, because who would foresee either at the time a contract is made or at the time of a tortious wrong that they're dealing with somebody who is a crank and doesn't want to do what is reasonable to make their situation better? Unfortunately, that explanation does not hold much water in my view either, not any more than the causation explanation. Because if this is correct, then it would imply that any costs of mitigation or any additional loss that a party suffers while trying to mitigate that offends the relevant rule of remoteness shouldn't be recoverable either. But that doesn't seem to be the case. In reality, it looks as though mitigation can, in some circumstances, basically grant an exception or an exemption from the relevant rule of remoteness to expand recovery, even though it looks as though the loss in question is simply too remote for that party to recover under ordinary principles. And the example I was referring to is a case called the Sivind. Now, the Sivind was a ship. It was a tanker that managed to somehow collide with an oil terminal on the Humber estuary in England. This collision, as you would imagine, with an oil terminal caused some problems because you can't really operate an oil terminal that's leaking. So the owners of the oil terminal had to take steps to fix the terminal before they could get it back online and up and running. To do that, they hired a firm that specialized in this kind of thing and had a special ship that would sink legs into the seafloor beneath the vessel in order to stabilize it, and then they would set up a crane and they would do the necessary repair work. Unfortunately for the plaintiffs, the owners of the terminal, this specialized ship sunk its legs into a piece of the seafloor that was unstable, causing the ship to capsize, leading to its complete and utter loss, because an upside-down ship is generally not a functional ship. So what of this additional cost? Well, under the contract for repair that the plaintiffs entered into, the plaintiff had to pay the initial cost caused by the total loss of this vessel. And as such, they were now looking at not just the cost of the repair to get the terminal back up and running, but the cost of the ship. And so when they eventually sued the defendants whose vessel had damaged their oil terminal, they sought to recover this additional amount caused by the capsized repair ship. And that was something of a fight, because whilst the rest of the repair costs, which were attributable to the ship colliding with the terminal, seemed pretty obviously recoverable in tort, the additional cost of a ship flipping over 180 degrees because of an unknown and unforeseen instability in the ground beneath the water did not seem as though it ought to be attributable, or at least according to the defendants, to them. And in truth, there is no argument that the capsizing ship was within the ordinary remoteness applicable in tort. Most of the judges acknowledge that it's a bit of a stretch in this case. One explicitly says it's just far too remote. You can't possibly suggest that this is somehow something someone could foresee, a ship that flips over completely and is lost. No, there was no way to investigate the seafloor to check whether it was unstable. There was no way to know that this was going to happen. It is not only practically unforeseeable, it is legally unforeseeable. But according to Lord Hobhouse, that shouldn't matter. If you as the plaintiff have taken reasonable steps to try to fix whatever has happened, then whatever those costs are, no matter how bizarre, ought to be recoverable. Because otherwise, how do we hold you responsible if you don't do it? We can't on the one hand say you must take steps to mitigate and then punish you if you do. Which seems to suggest that remoteness here is not driving the bus. It's simply another rule that otherwise applies to assessing damages that we sometimes dispense with because it seems unjust in the circumstances to hold the particular plaintiff to it. Now, the very last scenario, and after this, we're going to look at the problem question. So I hope you've all taken a moment to consider it in depth because I will be examining you on it. But the last example is accounting for the plaintiff's gain. So you recall from the very, very start of this presentation, which now feels like a month ago, that the early approach to mitigation basically took all subsequent events into account. So any post-breach or wrong gain was held to have mitigated the plaintiff's loss. Decisions of that sort include Staniforth itself and British Westinghouse, which I briefly mentioned. Another Canadian case from the SEC in the early part of the 20th century, Coburn and Guarantee Trustco, likewise took that approach and said, however you made that money, if it happened after the breach, well, you probably have to take it into account. So those damages are going to be reduced. Now, the position today is, I think, rather different. Courts have struggled to establish general principles, and I said this with some trepidation to the National Judicial Institute because it was a room full of judges. But I think that there is a little bit of a challenge with trying to extract a golden thread through some of these cases to explain why, in some cases, the gain should be held to account and why it shouldn't. I have my own idea, which is what I put in my doctoral work. But I think two cases help to make this more clearly than I do with all my lengthy prose. So the two cases in question are Hussey and Eales and the Federal Court of Appeal case here in Canada, Red Path. Now, Hussey was an English Court of Appeal case, and it involves a regular couple, the Husseys, who bought a house, as people used to do. Not people like me, but other people. They bought a house, but then found out that the house suffered from subsidence, which was unfortunate for them because who wants to sit in a house that is tilting sideways? All your things fall off the shelf, your cup of tea rolls off the table. And so they sued the Eales, who had sold them the house, for negligent misrepresentation about the state of the property's foundations. As things are wont to do, this took a while because the wheels of justice grind slowly. And in the meantime, the Husseys decided they would try to subdivide the property and build a new dwelling. They obtained the necessary planning permission, built a new dwelling, sold that, and then sold the initial property. In so doing, they made a very tidy profit. In fact, so much money that it eliminated the loss that they suffered in the first place as a consequence of the negligent misrepresentation. And that raised the question, are they actually any worse off? They wouldn't have subdivided the land and built the other bungalow and sold the land off at a profit, if not for the fact that this bungalow, or the initial building, was tilting this way. So could you attribute this gain to the defendant's inadvertent failure to disclose the fact that their house was slowly sinking on one side? Well, the court's conclusion was no. You shouldn't hold this gain made by the Husseys to the account of the Eales, although they don't really give a particularly persuasive account as to why that is the case. They say that the events of the subsidence, the negligent misrepresentation, were the occasion, but not the cause of the plaintiff's gain. I'm not quite sure what that means. They go into a bit of discussion about the difference between res injurios acta or causa causans. I forget the Latin phrase. In the end, they seem to think that the plaintiffs didn't do this for the defendant's benefit. That's their best stab at trying to provide a rationale. The problem is, though, when, if ever, does a plaintiff do anything for the defendant's benefit? Do I go out and think to myself, well, now that I've gotten my leg broken by this person, I need to go find a way to save them from damages. Let me find a way to work regardless of my injuries. Let me find a way to save you from legal liability that I will otherwise have to seek to wreak upon you. No one does that. No one thinks to themselves, gosh, I really want to help the guy who wronged me. That's what I'm going to do today. So it's not a particularly compelling analysis of the decision. But when you contrast it with the red path, I think it makes sense. Now, in the red path, the plaintiffs were purchasers of sugar. Red Path, the sugar company, who I'm sure you've seen in the grocery store. They bought a consignment of sugar from Guyana, which they were going to process in Toronto. Now, on the way to Toronto, unfortunately, the sugar was contaminated with seawater, which you can imagine makes it not all that palatable to most people. But what did Red Path do? Well, because they were a refiner of sugar, they were actually able to simply take steps to process the sugar a little bit more thoroughly in order to remove the effects of the seawater. And they were thus able to actually remediate the whole cargo and sell it as per normal. Nonetheless, Red Path sued the carrier, the ship, for the difference in value between the sugar as it arrived and the value it should have had if it arrived without contamination of the saltwater. Now, the Court of Appeal, the Federal Court of Appeal, concluded that, well, given that the costs here to Red Path were so modest, were so marginal, given that they were in the business of refining sugar and could actually tell you exactly how much more it cost them, there was no difference really between the value of the sugar they received and the value of the sugar that they should have gotten, because for them, the two were basically the same, but for some modest incremental cost in processing. And so the court said, yes, you, Red Path, have mitigated your loss by managing to make use of this product despite the defect. Now, the difference, I think, between Red Path and Hussey Neals is that in Hussey Neals, you just had a regular couple who weren't in the business of property development. They had no prior experience of having subdivided anything or built a home or sold anything. That wasn't their business. But they went through all the trouble required to figure out how to do this and to actually carry off the scheme in order to try to save their investment, because that's just what fortune threw at them, and they adapted as best they could. All the time and money they poured into making that happen, though, are a cost that has to be weighed against the fact that they made this profit. It wasn't an easy profit for them to make. This was something that was other and different for them. It wasn't the regular line of business. Whereas in Red Path was literally in the business of refining sugar. Sure, they refined it a little bit more, but really it was all in a day's work. So the difference in terms of the opportunity cost for Red Path and the opportunity cost for the Husseys appears to be that the Husseys had to learn a whole new business in order to make this profit. Whereas Red Path really just had to do what they were going to do anyway, but spend a little bit more time doing it. And so it appears to me that when it comes to accounting for gains, courts are taking into account not just whether or not you made the gain, but whether or not they can actually work out how much it cost you to make it, and to put a dollar figure on that in a way that means that they're not robbing you by taking that gain into account to reduce the defendant's damages. Because imagine that the gain is $30,000, but in terms of time and money, it's cost you $20,000. The court holds $30,000 to reduce your damages from the other party basically to nil. You are maybe $10,000 up in one sense, but if the damages that you should have gotten from the defendant are greater, you are actually left worse off. And if the court cannot ascertain clearly how much the time and capital cost to you of taking these steps really is, they risk undercompensating you as the plaintiff. And that is something I think that they're starting to shy away from doing, realizing that they cannot tell accurately in more complicated cases how much trouble the steps involved in mitigating actually were. So, in short, before I ask you to answer the problem, despite the fact that mitigation is a doctrine, this has been pointed out to me on a number of occasions. A number of people said to me, well, Krish, can you give me a chancery report that says something about mitigation? And I say, no. I'm like, well, then it can't be equitable, can it? I think it can be, because regardless of whether or not you believe in a substantive fusion of the two streams of jurisprudence following the Judicature Act amendments of the 19th century or not, the fact is modern superior courts have jurisdiction over both. They're administering both bodies of jurisprudence, and I can't see why they haven't somehow seen a migration of mitigation from one side of the aisle to the other. The way it operates also really seems to be keen to address either under or overcompensation and to prevent outcomes under the rules that, while strictly correct, seem somewhat perverse. And in so doing, what mitigation appears to be trying to accomplish is to prevent the purposes of damages being overwhelmed by the letter to which we've expressed them. It's trying to promote the purposes underlying the law, and that is what equity has always been about. All right, thank you very much for listening. All right. So I think everyone should have a copy of the problem question. If anybody doesn't have a paper copy, let me know. I think there are some more floating about. Just going to open my copy here on the screen. And I'll share it for our one Zoom viewer. Okay, share my screen. I need to have fewer windows open.
While you're doing that, I don't know if
Yes.
you wanted to open up 4 questions. If anybody
Yeah.
has any.
Sure.
I don't want to sort of like
No.
interrupt the flow of what you're planning with the problem. There may be some questions.
Yes. Yeah, sure. Well, I guess before the problem question, please, if anybody has anything they'd like to ask, let me just grab my coffee and then feel free. Yes, please.
Summary these days, but it seems that there's this weird sort of almost like epistemological thing of how much a court knows or can conceive of what effort has gone into steps, and maybe how would that get sort of in a court case if, you know, the defendant is like, you know, went too far to go and see costs. Like, it seems like there's this weird like spectrum of behavior that as a plaintiff needs to be acting on.
Yeah.
That is deemed appropriate or not appropriate, or
Yeah.
you know, very Denon has to be like, oh, they've obviously gone out of their way to, you know, create a new real estate company out of its stilted house.
Mhm.
Like that's enough effort. Where, you know, oh, it's commercially significant party. You know, we've already really kind of sugar. I feel like it seems like it's just treating them as very reductive conclusions about like effort or a sense, and like how does that a given court kind of like make an assessment or calculate any of those things in a decision or in a way that in a whole.
Sure. So I think in instances where a court can, with some confidence, come up with a figure to attach to the relevant effort that the plaintiff will have gone to in order to mitigate, they can reckon with whether or not there is a gain at all that you can hold to the defendant's account. The problem in circumstances where, not just for evidentiary reasons, but really epistemological reasons about what they actually can know and investigate, that sort of leads them to conclude that, well, we see that there is a nominal profit, but we don't really know how much really went into it. Like, how many sleepless nights do these people go through, you know, dealing with bureaucracy for planning permissions, and how much stress has this caused them, and so on. In situations like that, I think that they're inclined, or increasingly inclined, to say that, you know what, we see a dollar figure here that looks like a gain in terms of the sale of this property at a higher price. But what did it really cost you? The fact is, we can't really ascertain that meaningfully, or we're just not sure of it. And when they are so uncertain about the scale of the effort required, it seems inappropriate, in my mind, for them to decide that, yes, we will take these nominal figures and net them off against each other, because that cost component would be missed. And in a case like Redpath, because Redpath, as a refiner of sugar, is able to tell you exactly, this is how much more time we had to put it through, this is how much more water, this is how much more power, this is how much more wear and tear we would allocate to machinery on a depreciation basis, you can work out pretty finely what that cost was. And then you can really ascertain whether or not there really is a gain or not. But in situations where we are at best guessing, I think courts are increasingly loath to make that guess and potentially disadvantage the plaintiff. Yes, Brett.
Certainly, there are many cases in which the defendant not simply trying to offset the losses by the plaintiff, but actually claims the share of the profit earned by the plaintiff through their mitigation efforts, which on the not but for theory, but I hadn't reached it, you never would have done that, you never would have made all that money, so I want to share.
You know, I haven't seen a decision in which somebody has been quite that brazen, but it would be an amazing test case for a court to actually grapple with what this is all about. If someone were to say, well, look, but for my misbehavior, you wouldn't be this well off. I think that would lead to a very amused, but very confident court saying no. Because I think you would struggle to say, well, what's your cause of action?
But at the same time, you are arguing the defendant the benefit of mitigation efforts on the part of the plaintiff.
Mhm.
That only occur because.
Yeah.
So plaintiff should say, well, that allows the
Mhm.
defendant to mitigate their, the damages they might have otherwise faced.
Mhm.
That's why should they get a share of the profit?
Yeah, I mean,
The logic seems to be so illogical to give them such a full benefit. of
Yeah.
their own reach. That being illogical.
yeah, I mean, why are we holding the gain to reduce the damages if we're not even going to go as far as giving them a share of the profit made? Yeah, I think that there's a sort of amusing case to be made. I think that most courts would scratch their heads and say, I don't know why this is wrong, but I know it's wrong. I'll struggle to figure out an exact explanation for you, but I just know it smells weird, so I will decline. Yes, please. Oh, sorry, Diane, you. I think so. I think that what mitigation is doing in either situation is trying to further the purposes underpinning the cause of action. And in contract, I take the position that contracts are about generating surpluses from trade. So it's an economic efficiency perspective on what contracts are about. And so for reasons flowing from that, I say in certain circumstances, it's not appropriate to reduce damages, or it is appropriate to reduce damages because of how it affects the party's surplus position following entering into the contract. I don't think the same can be said for tort, even though some people would like to apply an economic lens to tort. I think that the dehumanizing aspect of quantifying suffering and so on in that way tends to put most people off, especially courts. And so I don't think you can take quite the same lens. I think you have to think about what exactly restitutio integrum means for the relevant party, what it means to try to put them in the position they would have been in, and ask whether or not reducing or perhaps increasing damages because of mitigation would further that. And if changing the damage award in that way would further the ultimate purpose of trying to restore people, then mitigation ought to apply. But that's a different question than what contract is trying to do. And so I think they have to apply quite differently, yes. Oh, I see two questions. Sorry, Rob. Oh, yeah.
I understand the purpose of mitigation.
Yeah.
And reduce the loss, but many things are not. So,
Mhm.
yeah.
Mhm.
I don't know,
Yeah,
doesn't reduce the debt.
right.
Things true with things reach contract courts. Many of them are compensation. But boy, I haven't read the Sugar case.
Yeah,
When you're told that that's the obviously you're not claiming compensation for loss, they're claiming
vindicatory.
You promised Brian you should have tax and
Mhm.
X minus whatever.
Yeah.
I'm not asking for compensation for loss. I don't want the value of performance you promised.
Yeah. Mhm. In some cases, I would say, yeah, there's a pretty compelling argument for leaving mitigation out of it. Asamira oil is one that always comes to mind, partly because I hate reading SD's judgment. I find it really hard to follow. I've never liked it. And I've had to read it multiple times because it was really relevant to my doctorate. I don't understand. In Astamira Oil, one party borrows shares from the other party. They're contractually obliged to return the shares. They don't return the shares. Plaintiff sues for return of the shares, seeks specific performance or damages in lieu. And to assess the value of the shares for the purposes of damages in lieu, you would normally take what was previously understood to be the highest intermediate value. In this instance, the court says you should have bought replacement shares at some point. Well, why should he? They're his shares. If somebody doesn't return my car, I don't go out and buy another car. It seems awfully cheeky for the defendant to say you should have bought other shares when it became clear I wasn't going to give them back. I don't know. It just seems very much letting the defendant have their cake and eat it. I don't like it. It seems a little too defendant friendly. And so it's one of the reasons why I hate the case. I just think it just seems so strange. In the sugar case, I can see what you're saying about seeking a return of what you should have had but didn't. And if you understand it as a matter of debt, then strictly speaking, mitigation doesn't apply. Mitigation does not apply to debt claims, and it doesn't apply to claims for the price. So if you're suing for a contract price as opposed to damages for breach, then you actually don't have to reduce damages for the contract price if that's all you're suing for, as opposed to the profit. And so there are some things clearly it doesn't stick to. In the red path example, I think because when you're dealing with a contractual right to delivery, it's not a right in the thing itself. It's not seen as debt. And so you just have to net off the value of what was provided from the value of what should have been provided. And that is in sales, typically understood, that's the measure of damages as the default. And that is understood to be subject to mitigation only because if it's a fungible good, if it's something like a bulk commodity like sugar or steel or coal or what have you, then it's typically understood that there's always a market. And the expectation is you must go into the market to find a substitute as soon as you're able, typically within a day or two for something like sugar or steel or anything which is traded internationally. So in that instance, I think because of the relative ease with which a party can go and enter into a substitute transaction, it's seen as applicable. For more specific property, for property that is unique and hard to replace, I think that you're right, that it does seem off to apply it, which is the Astamira case involving the shares, because it was a closely held company. He couldn't go out and buy replacement shares, really, unless he'd found another shareholder in the small company who would have sold him their shares. So I don't understand how readily possible it was for the plaintiff in that case to take those steps, or why they should have to, given that this wasn't property they were buying for further exploitation. It wasn't sugar they were going to refine and then sell. It was shares he was just going to own because they were his. It seems off in that case to apply it. But in the sale of goods context, I think courts are still pretty happy to apply it. But debt, you're right. Restitution claims, no mitigation. Anything which is gain-based, really, no mitigation. Yeah. Sorry, Dylan, did you have another question?
I don't think it's always involved in this has been started in total. There's definitely a duty on the client to mitigate.
Right.
It's perfectly recognized. But what's interesting is that it's always it rests on the past. And it recognizes that all plaintiffs aren't created equal.
Yeah, for sure.
Situation, and I think in that you do have a regular work almost impossible to have a discussion around litigation what they can do but they also realize that the court has to use it to be fair to both places.
Yes, yeah.
It's not, I had a very interesting case of injury in a mine, where a chap lost his lower leg. But what was fortunate for him again was that he retrained and did a day job, and was just finding that he was very good at the computer program.
Yeah. 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 Yeah, yeah. Right. In the long run.
With respect to the corporate is expected to indicate that with damage to the effect,
Mhm.
we are not neglecting the word of the benefits of the CBN.
Right.
Of how an unfortunate circumstance has a fortuitous consequence
Mhm.
to your individual.
Yeah.
And you can always say, well, basing from the side, and say, basing in this sort of website, which makes me laugh, but, so I think, yeah, it's fascinating, and you've also mentioned raising drawing and doctrine,
Mhm.
which is something that's also, very controversial.
Mhm. Yeah.
And what you can expect in the contract.
Yeah.
You don't, again, probably not something that you recognize in the name.
Yeah, it's described as a duty, but courts also say, even though that phrase is very widespread, because you don't actually have a claim against the plaintiff. Like, a defendant can't sue a plaintiff for failing to mitigate. So you can't really describe this as a duty per se, because it's not enforceable. There's no corresponding obligation in Hofeldian terms. So there seems to be an implicit understanding you ought to, but there's no requirement that you should. But because duty is just the way it was described in British Westinghouse in earlier cases, that's how we continue to say it. Actually, in Bellingham and Dillon, the case about the driving instructor, the court says we keep saying duty, but it's nonsense. And we all know it's nonsense, by the way. I'm stating it here for the record, just so everybody knows it. But we know that you don't have a duty. We just kind of frame it that way because we frame it as something you ought to do. But yeah, there's been a long running, I think, effort to try to explain this in a way that doesn't sound as though there's a mandatory responsibility, but there's never really been a phrase that caught on. Yes.
You're talking about around Latin accent or mitigation, well, my opinion, like the court may or may not look favorably on some of the policy items or like.
Oh.
I've heard of doing something, maybe not.
I like the passage from Lord Macmillan's speech from Banquet of Portugal and Waterloo and Sons, where he says, in the context of an emergency that has been caused by the defendant, it is not for the defendant to weigh on nice scales what the plaintiff might have done otherwise or better in order to retrieve themselves from the emergency that the defendant has created. Because I think a lot of what courts are trying to decide when they weigh up a defendant's plea, if failure to mitigate on the plaintiff's part, is they're trying to decide whether or not it really lies in the defendant's mouth to make that argument at all. Because in some circumstances, it seems as though they just don't have standing to make that argument because their own behavior sort of disentitles them from the court's equitable assistance to relieve them from the consequences of their breach or the tortious wrong. I haven't thought of a Latin expression for it, but yeah, you know what? Maybe that would help to get it to catch on. I am talking to a publisher next month about getting this book. So yeah. Mhm.
Also mentioned this, that, although there's no chancery case, bringing up mitigation, how does that play forward though the other? So how does, your analysis of mitigation as that comes up, how does it affect your thinking on whether there has been something like a substantive dispute or what's happening in the common law post that you're at?
Yeah. I probably, as a consequence of my initial training, New Zealand is, for the most part, a staunchly anti-fusion jurisdiction. Certainly the person who taught me equity was staunchly anti-fusion. I tend to think that the administrative union of the two separate strands of jurisprudence in one house means that a court is just better placed to apply an equitable doctrine to a common law issue. And that's all they're doing with mitigation. Like, mitigation is basically just somebody saying, well, yeah, I might be liable, or, I know that I technically don't have a claim for X, but it seems a little rough, doesn't it? Like, this person could have done this really easily to have, found a substitute for this contract that I breached, or, yes, there was a weird thing that happened while I was trying to mitigate, and it's caused a bigger loss, but I was doing my best. And I think, I mean, that's historically what you went to Chancery for. Like, you got a judgment in, common law in King's Bench or something that, was adverse, seemed contrary to conscience. And you said, well, that doesn't seem fair. I don't think that should be enforced. You run off to the chancellor and say, well, look at this judgment. I don't think that's right. And they would say, no, you're right. I'm not going to enforce that. Or, I'm going to enjoin the other party's conscience from enforcing that judgment. And I think that's really all the court's doing with mitigation. I think you can readily understand the two as distinct and separate. In fact, I think you almost have to understand them as separate, because the way I conceive of mitigation is that it sort of sits outside of the rules regulating contract or tort damages. It's kind of a regulator. Like, it's sort of supervising the overall operation of these rules to make sure that none of them goes too far astray. Because the rules that we have, whether it's remoteness, causation, whatever they are applicable to how we assess damages, are always open to under or over inclusion. Like, that's just the nature of a rule. It'll catch some things that it shouldn't, and it won't catch some things that it should. And what mitigation does is it tries to prevent those situations where something is going to fall through the cracks and lead to a somewhat unjust outcome that doesn't really line up with why we're doing this in the first place. And so I think you have to conceive of equity as separate for that reason, or at least I do. Yeah. Great question, I think. Oh, problem question. If nobody else has any other questions, we can look at the fact scenario. But if there are more questions, please feel free. Probably only have a few more minutes. No other questions? No. Okay.
Sorry, before you
Yeah.
I'm gonna have to take one of these soon, and I don't, because I have to teach in just a couple of minutes.
Mhm.
So I wonder if, for my sake, we could all just thank Chris for a very interesting presentation.
Oh, thank you very much.
And so aptly demonstrating the power of cases in pulling apart really complex and fascinating legal questions, which, as some of these generally in the realm of public law, we don't get to do often. So thank you very much.
Oh, my pleasure.
And just as well, if anybody else has some tea while you're
Oh,
through your exam together,
yeah.
please enjoy. But I'll sit for a little while and please excuse me.
Yeah, no problem. I understand, of course. Yeah.
Thank you for coming. And look forward in the schedule for the walk back. We have our next session, the research series session. I forgot the date. So just kind of post. August 14th. I can't remember, but we're having a presentation from three of our
including Rob,
Professor Chambers, on writing textbooks effectively. So sorry to kind of interrupt this.
No problem at all. So, show of hands, who thinks the owners should have their $18 million profit held to the defendant's account to reduce their damages claim? Okay, I see one hand, I see two. Who says no? Who says no holding that profit to account? Okay, I see one. I see a nose rub and a 1, 2.
What do you think?
Well, let's focus on the outcome under the doctrine as I explained. Yes. Yeah. Yeah.
The claims for the lost profits
Mhm.
from the chart.
The charter. Yeah.
Across the charter, what the defendant-
Oh, okay. Yeah, like
the higher value of the vessel, not consequential gains. Is that all?
so profit from the charter. So they would be operating the cruise ship and they would be, taking passengers, and so they'd be getting revenues from the passengers on the ship. Actually,
But this is the owner's claim.
this is the owner. So the owners, I guess, would have been,
They granted the charter.
Yeah.
They're expecting money.
their profits, I think, would have been, so I think they would have made profit off the difference between operating costs. I'm trying to remember, this is based on a real case. I'm trying to remember what the actual nature of the claim was. So yeah, the owners, they weren't operating, it was the charters. Yeah, no, I think the owners would have been, so I think the owners were responsible for certain costs associated with the vessel. So maintenance and so on. So the charterer was operating it as a cruise ship, but like a lot of the other maintenance costs and so on, we're still on the owner. Yeah, minus upkeep and so on. Yeah, so it's that difference between the rent and expenses. So that's it. Yeah, no problem. Yeah, so $18 million. That's how much more the ship would have been worth, or was in fact worth, when it was sold versus what it would have been worth at the end of the charter. I see that there's a bit of disagreement about whether or not you should factor in that difference in capital value. Does anybody want to share with me their thoughts as to why you should or shouldn't take it into account to reduce the damages? No? Oh, okay. The Dean, that's her. Please.
I feel like the thing that was in the Hussey example was just that there's a degree of sophistication of it. This is a company that like rents or charters boats.
Yeah.
The business boat, the fact
Yeah.
that they're making money from the sale is a pretty natural extension of what they're otherwise doing.
Mhm.
I would think maybe a mitigating factor in what extent they're able to get them to some involved. So
Mhm.
it could have been, a one person renting out a rowboat and then
Mhm.
being able to get, anything sort of from it from trying to charter it out again.
Mhm.
It would be different, but trying to sort of channel that a little bit into the equitable. It seems as if they should be held, that the 18 million should be factored into how the thing itself like 5 people.
Okay, all right, fair. Andrew?
So on the same page, I mean, against what I just voted for. I think it's interesting, there's a potential difference between, you could see this as similar to the Husky, where they retrained in an entirely different field and did something different.
Yeah.
I can see an argument that, well, selling the boat, or otherwise just leasing out.
Yeah. Mm-hmm. Okay. Please. Mm-hmm. Mm-hmm.
Debit credit.
Mm-hmm. Yes.
They say, oh, well, we're not going to do the promise to do.
Mm-hmm.
That is the trigger.
Mm-hmm.
This is on out of pocket.
Mm-hmm.
Now you say, one, two, because they are pointing to whatever they do.
Mm-hmm.
So on that sheet, concrete project is done with before and after, kind of, understanding, do you have a loss or not?
Mm-hmm.
And if the answer is yes, you sue, answer is no, then you don't.
Mm-hmm.
You know what I'm saying?
Mm.
Kind of this just they runs, not even looking at, equity or anything at the fact.
Mm-hmm. Yeah. Yes. Yeah, no, that's, yeah. That's where Arthur start. Yes.
He did no further wrong. He contacted me. You know, this is the third one. If we're trying to turn around, you know, what shit break is all right. I think what we have to go on is what the wrong or what wrong happened. Unless we're looking at the market all the way into,
Mm.
Like.
Sorry, there's another hand. Sorry, Rob, I think it was Robert Brad first. Rob, please. Mm-hmm. 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 Yeah. No. Fair. Yeah. I mean, it is hard to imagine what you were saying before about Red Path and so on. Yeah. And like an action for the price. Yes.
It just seems to be fundamentally wrong, rewarding the wrong group.
Mm-hmm.
Five, so happened that the plaintiff has been able to cover it. Arguably better.
Mm-hmm.
That's a whole bunch of unknowns.
Mhm.
Because if they still own the boat today, maybe we were 25 minutes, 18, you know, a lot of unknown, but anyway, we know the wrongdoer breached the contract.
Mhm.
So why should they end up with no penalty? The only thing, what also needs to be wondering is, what does the court do if they deny the claim? Do they award costs to the wrongdoer?
Yeah, typically. Yeah. Costs and the cause usually. Yeah, no, it's. Mm,
So are you inequitable? Hence the joy of having equity.
yeah. The interesting thing about the case that this is based on is that it actually flipped at each level. So it started at arbitration, was appealed, was overturned at the High Court, and then overturned by the Court of Appeal, and then finally overturned again by the UKSC. So you have a very distinguished group of jurists at each level who all disagree with one another. So the Supreme Court agreed with the High Court, and the Court of Appeal agreed with the arbitrator, and everyone thinks that everyone else has sort of missed the point. This is one that aroused quite a bit of discussion and quite a bit of fury when it was handed down. The final outcome, according to the UK Supreme Court, was that you should exclude it from consideration, that you shouldn't take it into account for purposes of reducing the loss claimed by the plaintiff.
But I assume that we will offset some of the costs of the plaintiff.
Well, that's the thing that
yes, there's a $5 million contract that they had expenses.
yes. Yes, yeah. So the plaintiffs in this case were only suing for the profit that they would have made. So they're saying, you know, don't give us like the revenue figure, including the expenses we didn't incur, just the profit figure that we didn't get a chance to earn. The majority rationale, I agree with the UKSC, but I feel like I think they've missed, to Dalian's point, I think a really key aspect of understanding whether or not there is actually a loss to reckon with at all, which is if the fundamental purpose of contract damages is to put you in as good a position as you would have been, you have to ask, when you weigh up everything that's happened, what kind of position is the plaintiff actually in? Now, it's true, they have $18 million more than they would have had if the charter had gone ahead, because they were able to sell the ship when it was worth more at the prevailing price in the market for ships. But they also would have had a ship. So if you take the capital value of the ship into account to reduce the revenue loss or the profit, which is on a revenue account, you're taking apples and oranges and comparing them. And so you're leaving the plaintiff worse off, because not only did they not get a chance to make a profit from the ship, they're now without a ship and having to find a way to now redeploy their capital for some other business, whatever would have made sense at that time. And you know, between 2007 and really the next 4 or 5 years have been a rough time economically for anybody. So it seems as though taking into consideration that capital value equates something that is outside the scope of the contract. And to the point about whether or not, you know, claiming for the contract price is really in this instance a claim for debt and why you shouldn't be able to hold that account. I think the reason why courts below were of the opinion that that's not an issue here is because they're seeking the profit, not the price, and because the contract wasn't performed. If the contract was fully performed, then an action for the price is just an action in debt, and an action in debt cannot be subject to mitigation. Because here they're seeking profits that they would have made if they had operated the ship, which is prospective and didn't happen. Mitigation is said to be applicable. But when somebody has changed their circumstances in a way that makes them, if not necessarily worse off, but different, I don't see how you say that mitigation ought to apply here, because we don't know that they're actually better off or the same, because they don't have the boat. But these things get quite thorny. So hopefully that example, if you want to look it up, the case is called the New Flamenco. It's the name of the ship. It's a great thing about English maritime cases. They name the cases after the boat. Yeah, you can find it probably on any service that carries UK Supreme Court decisions, probably the UKSC website. All right, well, thank you very much, everyone. I really appreciated this. Been a wonderful audience. All right, I'm just gonna log out. This Chowdhury, I hope you've enjoyed.